Good evening. I'm Patty Horvath. I'm the Director of Operations for the Allegheny County Law Library. We want to welcome you to our first live remote event. We have had many CLEs on our site, and we hope to have many more of our live remote CLEs / events, community events, some of which will be co-sponsored, as tonight's is, with the Pennsylvanians for Modern Courts, and some we will do on our own with our own staff and special speakers. Some will be free, as tonight's is, and some will be paid, which will be $25 a credit for non-members and $10 a credit for members. That's fairly cheap, and you'll notice the difference when you get to 3 credits. The Allegheny County Law Library is located in the City County building in downtown Pittsburgh. We're at 414 Grant Street in room 921. You can go to our webpage and find out more information about us and about our membership benefits at acllib.org, or just type in Allegheny County Law Library, you'll get to us. So that's my introduction, and I'll turn it over to Lori.
Oh, okay. Just click. Good evening and welcome. My name is Lori Hagan, and I help arrange the CLEs here. If you want a CLE credit for this, if we haven't already touched base and I don't have your PA attorney number, that's what I need for you to get credit. It takes about a month for the credits to appear, but as soon as they do, they will be credited to the time period in which you took it. So without further ado, I'm going to hand it over to Tom Bailey right now.
Good evening. My name is Tom Bailey. I am the Pittsburgh staff person for Pennsylvanians for Modern Courts. I have 2 messages for our Zoom audience. First, if there are technical issues during the presentation, if you would please call 412-467-9262. That is my phone number. I'm going to be here in the classroom. We will try to address your issues. Second, if you have questions you'd like to ask our presenters, if you could type them into the chat, we will look at those and at the end of the proceeding. For our live audience here, if we have questions, we're going to also try to address those at the end of the presentation. Our session is being recorded and will be available on the Allegheny County Law Library website, as well as Pennsylvanians for Modern Courts. Debbie Gross, President of Pennsylvanians for Modern Courts, will now discuss the background of PMC, and then she will introduce our presenters.
Great. Thank you very much, Tom. Thank you very, very much, the Allegheny County Law Library. Lori, we so appreciate this partnership with you. Wanted to let you know a little bit about Pennsylvanians for Modern Courts. We are a statewide organization. We are the only nonpartisan nonprofit organization dedicated to ensuring that all Pennsylvanians can come to the courts with confidence that they will be heard by qualified, fair, and impartial judges. Last evening, we held a appellate court judicial candidate forum where we had the candidates for the Supreme, Superior, and Commonwealth courts ask questions. We had over 400 people sign up for this forum. It's really, and so I'm giving a plug. It is really important that you make sure you register to vote, that you get out and vote for judges. The elections are in November. Please make sure you do that. We need to educate ourselves about the courts, educate ourselves about judges, and you are an important part of ensuring our democracy. I want to thank so very much the 2 magistrate district judges who are helping us with today's program. I have the honor of serving with Judge King on the Magisterial Judicial Education Board. I just joined. He has been I will say, a guiding light in helping me learn about the Magisterial District Judicial Education Board. And he is truly compassionate and caring and will shed a lot of light on landlord-tenant matters. Judge Barton, I unfortunately have not yet had the opportunity to meet you. Hopefully I will get out to Pittsburgh, but I want to thank you very much for agreeing to assist Pennsylvanians for Modern Courts in this program. Judge Barton is a magisterial district judge in the Mountain Lebanon district. I'm not sure of the districts. I hope each of you will list your district and your offices. And he is also an attorney who is in private practice. So I'm going to pass this off to the judges. I just want to give you a heads up. There is a chance every once in a while I may interrupt and ask a question, but I am going to leave it up to you. And I thank you again very much for joining us.
Thank you, Laurie, Tom, Patty, and Debbie, and thank you, Judge King. I guess there's a series of slides that we want to cover. Again, big reminder though, I'm sure during the presentation you're going to have some questions. So if you type those questions into the chat when we get to the question and answer segment, that will enable us to take the online questions. What to know before going to court? Well, I guess the first slide that I'll cover is where do landlord-tenant disputes fit in? And I know the lawyers in the audience will have seen the pyramid presentation of the Pennsylvania judiciary. At the top, of course, is the Supreme Court of Pennsylvania, the Superior Court and the Commonwealth Court, the intermediate courts of appeal. Below them is the courts of general jurisdiction all across Pennsylvania, the courts of common pleas for each counties or for judicial districts in a couple cases where that district spans several counties. And then at the lowest level, you have Judge King and I with magisterial district courts. You also have some other community or municipal courts. In Philadelphia, for instance, landlord-tenant disputes, I think are going to be before the Philadelphia Municipal Court. Here in Allegheny County, they are filed before a magisterial district judge for whose jurisdiction covers the property involved. In my instance, I cover several municipalities in the South Hills of Pittsburgh, Whitehall Borough, Castle Shannon Borough, and Baldwin Township. Judge King, what is your district again?
I have 4 wards of the city of Pittsburgh. It includes a lot of neighborhoods and unique to the city of Pittsburgh and Allegheny County. One municipality totally surrounded by the city called the Borough of Mount Olive.
Well, for magisterial district courts, and this is a common theme you'll see on the slide, our civil jurisdiction is limited in amount. Right now, it's $12,000 exclusive of interest and costs. You can waive a greater amount. So if a landlord is owed $14,000, they could decide to waive some of that and proceed before a magisterial district judge. The advantage there is the very rapid progression of landlord-tenant matters. Under the state court rules, for instance, we set a hearing 7 to 15 days after the filing of a complaint. Some of the other things we do, though, we handle summary offenses, so less serious criminal matters or municipal matters, violations of municipal ordinances. And then we have a broad and probably for most magisterial district judges, 75 or 80% of their time is spent with what we would consider criminal matters, whether it's misdemeanors, felonies, or homicide cases, issuing search warrants and arrest warrants, holding preliminary hearings to determine if there's sufficient evidence against the defendant to merit the case being bound over for trial in the Court of Common Pleas, as well as a number of other criminal and quasi-criminal things, such as issuing protection from abuse orders, emergency protection from abuse orders, when the Court of Common Pleas Family Division here in Allegheny County is unavailable. So that's going to be afternoons, evenings, and weekends. There's always a magisterial district judge on duty at Pittsburgh Municipal Court at 660 First Avenue. So PFA Plaintiffs can always have a petition heard, even if it's on a weekend or overnight, recognizing the often urgent nature of those kinds of matters.
All right, and first, the slide you're seeing now are the tenants' rights. They start off with stating that with the federal law and the Pennsylvania law explain that they have obviously the discrimination laws for housing, and that would be cover anywhere from rental or actually trying to purchase a house through a real estate agent or a mortgage broker. And it's the normal gamut of, age, color, religion, natural origin, sex, gender, sexual orientation, disability, or family status. And in the rental end of it, what would come up primarily would be someone would either look at a house or inquire about renting a house or an apartment and hear one price, maybe show up to say, can I view it? And then all of a sudden, for some unknown reason, it's already rented. And then the next day they'll have someone else call and say, no, it's still not rented. And obviously they were discriminated against for one of those reasons, and they can file. Mostly it would be, really wouldn't be anything they would file in our court. They'd have to go through HUD or Pennsylvania Human Relations Commission, or even locally with Allegheny County with the Department of on Human Rights. It wouldn't be anything that was filed here. The next slide, and there's some examples there.
And again, as Judge King touched, we don't typically see housing discrimination cases. Those are handled by some of the administrative agencies that have the capability to do some investigation as well as reach out to landlords. So the slide has some examples of what might happen by way of discrimination. And of course, the agencies such as the Fair Housing Partnership here in Allegheny County are adept at addressing those promptly and then taking whatever court action may be required. I'm talking about some of the other rights that tenants have. And these are some general slides. We don't always necessarily see a lot of cases involving some of these, but a landlord cannot take or sell a tenant's property if they do not pay rent. While it's true, though, that they can't just informally do that, I suppose it's also true that if a landlord receives a judgment, which potentially includes a money judgment along with an order of eviction, which, an order for possession, they could later in time, if a tenant abandons property at the leased premises, get an order of execution, have a constable levy upon, seize, and sell that personal property. So again, that's pretty far down the rabbit hole that we don't see a whole lot. Some other things, they can't shut off the electricity or the water. They can't harass tenants, and we see those sorts of cases more than you might think sometimes. They're supposed to give, unless it's an emergency, reasonable notice in the event that they intend to come into the leased premises. And that's something that's really important because one of the core concepts of a lease is the covenant of quiet enjoyment. And when a landlord starts breaching that covenant, there are serious consequences. They can't require a deposit for an assistance animal. And that opens up a whole nother area of law that's evolving now as well. They can't cancel the your existing lease if they sell the property. And as I tell clients sometimes, and landlords and tenants other times, look, having a rental property with a paying tenant is an asset to that property. When the landlord goes to sell that property, the fact that you have 4 apartments, they're all renting and they're all paying rent, that makes that house more valuable and that building more valuable to a potential buyer because they're looking at the cash that's going to spin off rather than having 3 vacancies or 4 vacancies.
Before you go with that, just to touch real quick, probably the most common is the shutting off of a utility, be it water or gas. And that usually happens before they file a case with us. And then the tenant will call, or they'll call the police first. And the police say, you have to go up to the local office. We tell them at this point in time, there's not much you can do. You could try to file a case or sue them civilly. The same with the, can you go back to the slide? Which one's back?
Can you go back one?
Yes.
Thank you.
And the harassment part too, they'll call the police, at least, I'm doing as far as the city of Pittsburgh. As soon as the police find out it's a landlord-tenant case, they just send them to our office. And now, what do? You want to file a private criminal complaint for harassment, maybe. And then eventually you'll see a landlord file, and then that'll come up in the hearing that will, 2 different times they shut my water off for 3 days, trying to force me out. And now, now they're here filing legally. And then you have to deal with all that. But that's really two of the biggest common, the harassment part and the shut off of some type of.
Landlords, of course, also have rights. They're the owner of the fee of the property. Landlord has a right to set reasonable rules and regulations. They should either be incorporated in the lease or referenced in the lease that may be amended from time to time. But of course, they need to be given to the tenant. And fundamentally, they need to be reasonable. Because if they're unreasonable, you're going to start venturing into affecting that covenant, the covenant of quiet enjoyment. And again, that's when we're going to start looking at potentially deducting what rent might be due and abating the rent. The landlord is entitled to have keys to the property. So if the tenant does change the locks, they really need to give the landlord a copy of that. The landlord can enter in case of emergency without notice. So if water's coming down the steps from the bathtub upstairs because a pipe is broken, they don't need to give you 24 hours notice. They're of course coming right in. But if it's a routine inspection for insurance purposes, they need to give you reasonable notice. Most leases have 24 or 48 hours as a term that's contained within the lease. It depends, but in the absence of some specified number, I think the issue becomes one of reasonableness. Landlords have the right to evict a tenant if they do not pay rent. Let's stop right here because do they have a right to evict a tenant? Well, not a self-help eviction. You in fact they have to file a complaint with, and we're talking in the context of Allegheny County, before the magisterial district judge, which then starts a whole chain of events into motion that we're going to talk about in a second. I guess the next entry is they must pursue evictions through the court system. Of course, although let me tell you, that doesn't always happen. And it's shocking sometimes that it doesn't. Landlords may require security deposits consistent with Pennsylvania law to secure them from damage that a tenant might do. And they're not responsible for tenants' personal belongings. If something goes missing, unless they took it and entered, they're not going to be responsible for that.
As far as the tenant responsibilities, the tenant main responsibility is to pay the rent and pay it on time. There are also, other different conditions that are in the lease. If you're in a multi-unit building, obviously something that's just as important as that quiet enjoyment clause, because it's, people are all living together and they have to at least have some respect of each other's quiet time. They also must obey the terms of the lease, like I stated, of having other options. If they have to pay the utilities, they have to pay the utilities. That's another one that gets tricky with us. And the landlord many times wants to fill that apartment. It's in the lease, they've signed it, they have to do all the utilities, gas and electric, sewage. They let them move in. They can't get the gas and electric sewage right away. So they start leaving it in the landlord's name and then they start paying them. And that goes by for a few months and then obviously they quit paying the landlord. They come in, they want to file. I always ask the landlord, you went past being the probationary period to get your utilities in, and you kind of already reestablished in your lease somewhat. You're now agreeing to do that. Have you provided them a bill at least and things like that? But usually they always have to require that. Section 8 lease is very good in that. I have a lot of Section 8. They have the blocks. They're checked off ahead of time saying that, because for a long time we were seeing those little so-called secondary leases with landlords that they would agree to actually pay utilities when they didn't, and explain to them that they have no right to do that under Section 8. The tenant also has to communicate to the landlord about repairs. That's another issue that we'll see that you only hear about it at hearing time, but and it should be stressed. If you have issues and they're not fixing them, you get something in writing and you get it to them right away. And then if they don't, before a case is filed, you can call the Allegheny County Health Department here in our county and have them try to come out and do an inspection. They will not act once a case is filed, and that's a big problem because a lot of times tenants don't either realize or bother to do it or call them on issues until after they file a landlord-tenant case. So they've kind of removed themselves from being someone only called after the fact. So they involved.
Judge King, what percentage of cases where they go to landlord-tenant would you estimate that the tenant says, oh, and another thing, last year in February, I called them because the bathtub was dripping and they didn't fix it until July?
A lot. There's after the fact problems brought up a lot that and the landlords usually act surprised or they are surprised, one or the other. And I asked them very simple questions. Big problem, and if there's besides any attorneys, it's my understanding there's some advocate groups that may be watching this too. One of the biggest thing you can do is tell them, you can tell someone to read that lease all you want, and usually they're just initialing all the different parts on it, signing their name at the bottom because they want to move into that place. What's on their mind? But just to stress the 3 or 4 basic things to really look for, and that's one of them. If you have issues, get it in writing and complain about it. Don't wait. And then actually you then have some documentation down the line if there is a landlord-tenant case that you truly did ask to address. And now, you have a $350 water bill because the toilet's been leaking, and you have in writing that 3 months ago you told them the toilet was running and they never came out. So, now you can actually show you did something.
And at this point, it's important that they complain, but complain in a manner that you can prove that you complained. Correct. So send a letter, and then another great idea is keep a copy of that letter.
And I'm going to interrupt you because it can be more, it can be not even a letter. It could just be an email. It could be a text, right? As long as it's something where the writing can be shown to a judge.
Absolutely. And in fact, printed text messages, I think, are well established as the dog proof in these kinds of cases.
Yeah, absolutely. We're for sure the text.
So let's move on. Let's talk a little bit about the landlord responsibilities to maintain the property in a safe condition. Fundamental. Provide drinking water, bathroom with toilet, heat, all that kind of stuff. Every residential lease in Pennsylvania has an implied warranty of habitability that was established by the landmark case of Pugh versus Holmes in 1973 by the Pennsylvania Supreme Court. And so when the furnace stops working for 2 weeks in February, a tenant is probably going to be entitled to an abatement of rent for the month of February. And so the landlord does have responsibilities such as the ones shown here for providing some of the basics that I think everybody would expect for a residential lease. Moving on, and this is sort of a new and evolving lead paint and lead pipes. Of course, it's been the law for a long time that a landlord is supposed to give you the lead paint disclosure when you move in and so forth. Separate utility meters. The days of, there's 1 meter for 3 apartments, so I just split it 3 ways, have long since ended, and they're required to have separate meters for utilities. There probably are still landlords that are doing it the way that it was done 40 years ago, but that's going to be a problem when it comes time to try to collect that. When the tenant says, look, I don't have a separate meter, I don't know, I live alone, and the other 2 apartments are families with 4 and 5 people, So why should I be expected to pay $82 a month for water when I take a shower, once a day and I'm at work all day and so forth? In addition, with respect to smoke detectors, again, text, email, or send a letter to the landlord. They're supposed to be very prompt in doing that. And to the landlords, I would say, oh my goodness, get out there sooner than 72 hours. It costs $15. And can you imagine the insurance claim if something happens and somebody is killed or injured?
All right, as far as what is in the lease is an agreement between the landlord and the tenant. The tenant can occupy and use the property for a certain amount of time in exchange for rent. Some issues that pop up sometimes is how many people, who's on the lease. Is someone an overnight guest, 1 week guest, or are they there all the time? That comes up a lot. Landlords want to use that as a material breach to evict and get instant possession. It comes into a point of proving, are they getting mail there? I mean, if the mail, the thing of getting mail to a mailbox kind of shows that someone else is truly living there. So that's a little bit tough for a landlord to prove that someone is living there all the time. It's a big step for them to do, and it pops up a lot. Be sure you understand at least when you're signing it. Again, like I stated, that's a big thing. A lot of times people that are renting, they just want to sign the lease. They want to move in. They maybe moved out from somewhere else. They got rented a truck, or got their cousin's vehicle for the weekend, and they just want to get in, and they don't really sit down and take the time to read and understand it. That's very
and that's critical. The source of tons of problems. Now, look, frankly, who reads leases? So obviously, when we went to law school, they made me promise that I would read everything before I sign it, and I often do. But in the real world, I think folks are focused on moving in tomorrow, next week, and this weekend, and less concerned with some of the details. So the questions, I suppose, ultimately arises, were all of those terms fairly bargained for? Well, that remains to be seen, but you didn't question it when you had the opportunity to question it. So one presumes that you must have agreed to it. What can a lease contain? Of course, obviously the basics, identifying the property, the term, the rent, the details. Judge King talked about visitors and so forth. Obviously things like utilities and some other things. At the bottom of this slide, one of the most important things, I think every written lease I've ever seen, unless it was prepared by an attorney committing malpractice, contains a waiver of the notice to quit provision in the Landlord-Tenant Act of, I think it's 1952. And that is waivable. Otherwise, before the landlord can file, they must give a clear and unequivocal notice to quit that must be served upon the tenant by hand or perhaps taped to the door. But you can't just put it in, put a 52-cent or whatever the stamp is anymore in the mail and say, oh, well, I sent it to them. Because this is a jurisdictional defect. If the plaintiff files before 30 days after having served this, they may wait 2 weeks to get a hearing. Maybe there's a continuance of another week or two. They come, the tenant may walk in, perhaps represented by a lawyer from Neighborhood Legal Services who's going to say, Judge, here's the lease in this case. There's no waiver of the notice to quit. They never served a notice to quit, or they served the notice to quit Thursday and filed this case on Tuesday. So it was, 5 days in between service of the notice to quit and the filing of the case. That's a jurisdictional defect. I would request that the court dismiss this case and put them back to serving a new notice to quit, waiting 30 days, and then filing. And I think that's going to be granted in every court all across Pennsylvania, right? Because that's simply
and there is some talk of some groups that are approaching the state legislature to amend the landlord-tenant law and take the right to that waiver away to make sure that that a landlord always needs to put them on notice that they are going to go to court and have that in there. So where that stands, I don't know right now, but I know that there are groups approaching legislators to discuss about maybe amending.
Talking about resolving issues outside of court. Obviously, again, you need to do something when you're a tenant or when you're a landlord and you're communicating with the other party. You probably ought to do it especially when we get to the more formal notices. Look, if you want to send a text to the tenant that says, hey, today is September 22nd, we're still waiting for rent. So you owe $800 plus now $50 late fee. Do you know when you're going to be paying it? I suppose there's no reason that needs to necessarily be more formal than a text message or whatever. But when you start getting into the other notices, I think it's advisable for either party to do so by some means that you can prove later on in the litigation that, I did complain, I did request this, I did do that. Security deposit, and that's all, we could spend the whole nother hour talking about security deposit law. But fundamentally, in the most boiled down sense, when the tenant leaves, they need to give the landlord a forwarding address in writing. I suppose a text message does it. That starts the clock ticking. The landlord has 30 days in which to send a letter to the tenant stating, look, you moved out. I'm holding an $800 security deposit. I found these problems, this damage, $200 to repair this, $200 to repair that. That's $400. So here's a check for the other $400 of your $800 security deposit. Or it's $2,200. So please remit a check for whatever that difference calculates out to be. But that 30 days is critical because if they don't, then their ability to collect for damages is gone. And I just had a case, I think perhaps last week, where the landlord didn't send that letter because the tenant filed a civil case against them. And he said, I'm surely not going to send the money back. And I thought I'd just wait and talk about it here when we got to court. Unfortunately, Pennsylvania law is clear in that regard.
Right. And another issue with the security deposit is who decides when or if they're going to try to apply it to any unpaid rent. I explain to landlords a lot of time, it's for the security of the leased premises, it's for the walls, the building, the toilet, the light fixtures. And if you're even going to attempt that, or you think you have an agreement with the tenant to say any unused portion will go to unpaid rent, put that in writing and send it to them. Because if you don't, or the tenant said, I know nothing about any unpaid rent, it's going to be, you're going to have issues if they come in and they want to sue you and they want to sue for that double. So, it's for the security of the leased premises. If you're going to get into applying it for unpaid rent, you better make sure that you've documented that with the tenant too.
Last item on this slide, talking about resolving things out of court with repairs. Look, things are dealt with all the time out of court between landlords and tenants dealing with, look, well, I'll buy this and I'll just take $30 off of next month's rent and everything is fine. Of course, if you don't write it down when things blow up, trying to establish what the agreement was is going to be a problem. And the repair in the duct, what I've over the years called the tenant's trio of defenses. One of them, when the landlord is breaching, is you can repair in the duct. But look, you need to have given them notice, right, and they don't fix it. They don't fix it. You finally tell them, look, if you don't, I'm going to do it. I'm going to take it off. If you still have no response from the landlord, then I think you're going to be fine in doing that. You can, of course, of the other items, you can simply say, look, you've breached, we're done, we're moving out. And under the law, your obligation to pay rent in the future ends because the landlord has breached the case.
What is an eviction? The landlord can decide to evict a tenant for 3 reasons. I believe there's a little bit more than 3, but the term of the lease is ended, the tenant violated the conditions of the lease, or the tenant has failed to pay rent. I've often said, people call them eviction cases, but they're landlord-tenant civil hearings. They're not necessarily, there's something that could involve and eventually end up as an eviction, but the primary is the non-payment of rent. That is by far the number one filing reason. Backed up along with the term of the lease ending. And we've seen a lot of that with the COVID issue of the not wanting to renew for various reasons, and more than I've ever seen as far as the end of lease condition. When they're filing just for rent, if you find it's a pay and stay situation. I get a lot of landlords that'll write or they'll check the box the violation of the condition of the lease, so I want to breach, and the reason of the breach is it's the third time they went to court, and they failed to pay, and I'll ask them, you're saying this, first of all, you have this in the lease. Well, there's nothing that covers that lease. I said, how can you say it's breaching the lease? You don't even have something written in your lease about multiple times to go to court, and so, you know, I'll say that, how can you claim that this is a breach? And have they paid? Well, if they've always satisfied the judgments, you got all your extra money, you got your court costs back. You know, they're failing to pay the rent. It ends up being a pay and stay situation.
To that, I would add, Judge King, that Pennsylvania law is generally clear that simply for the non-payment of rent, that's curable. They can pay that and continue to reside there under the terms of the lease. There is sort of a split of law at some point when you come to successive breaches for non-payment of rent. And there is certainly an argument that says, look, generally speaking, non-payment, we don't evict people, but they've breached the covenants of the lease, the fundamental covenant to pay, because we've had to come to court 3 times in the last 18 months. And it's just unreasonable to expect that I'm going to have to continue to chase and wait and file these court cases. That's not what I signed up for. And there is some split of opinion about whether that constitutes something for which we can evict you or not. And I suspect that a landlord's results across the county and across different counties may be uneven in that regard.
And that's correct.
Some evictions, you may not.
I'm of the mind, and I tell landlords, and I try to do little workshops with them when you can, because I have a lot of mom and pop. I mean, I have a lot of people who, I'll have a lot of that harassment stuff because they get personal because, you know, they have 2-3 places for at the most, and they get personal with their tenants. But, you know, put something in your lease about that multiple times having to go to court over the rent can be a breach of this. You know, now you're covered. If it's not, then it's going to be somebody's opinion if you are. Now, the next bullet point too, that's not exactly correct. In landlord-tenant cases, they can file the day of the hearing, and there's nothing that really fires up a landlord. The tenant will be there half an hour earlier, and they'll file out something. It's a much lower price to pay, and they'll ask for like $12,000 or whatever. And then you explain to them, okay, they filed this, and then they don't know the landlord-tenant law either. Well, they're allowed to. I can continue this since you just served with we can have the hearing right now, your choice. And if nothing fires them up like that, but they actually have the right to file right at the time of the hearing. The 5 days is for a straight civil case involving any type of dispute other than landlord-tenant.
One note too, with the box in the bottom, self-help evictions, and I know we touched on this briefly a little bit ago. When a landlord simply says, look, I'm not interested in paying the filing fee, waiting, going to court and going through all that stuff. It takes too much time, and my time is valuable. So I'm just going to change the locks. I'm going to put something on the front door on Thursday that says I'm changing the locks on Saturday, you're out. That is a serious matter. That's a serious matter, very serious matter in residential leases. It's a serious matter in commercial leases. And I can tell you that as a lawyer, I've gone into court for commercial leases where that has happened. And the tenant, when we leave with a court order, restoring the tenant back into those commercial premises that day, because it's dealt with very seriously. The landlords have to use the legal process in order to obtain possession of leased real property. There's a nice picture of Philadelphia City Hall.
Yeah.
For those of you in Allegheny County that don't know what it looks like. And it's a beautiful building, I'll tell you that.
I can't, that's a little small.
Yeah.
I'm gonna get the slide.
Okay, we're dependent upon Judge King's powers of sight, which it is a
I
little
have it
small.
here. I pulled it.
Fundamentally, civil suit is a suit between two litigants. One, the person who starts it, of course, is called the plaintiff. The other person against whom it is filed is the defendant. Determines whether defendant can be made liable to pay an amount of money. Of course, in the landlord-tenant context that we're talking about, I typically tell people, look, we have civil cases in MDJ courts where we award you a judgment for an amount of money. We have landlord-tenant case. A landlord-tenant case is a civil case fundamentally, but it has the added feature of we can control who is in possession of that real estate. So it still results in a judgment that you can collect through all the means that one can do with a judgment. And for execution of MDJ judgments, fundamentally you have a crossroads. You can stay at the MDJ level, get an order of execution, and then either you or the MDJ can find a constable who will levy upon, seize, and sell the non-perishable, tangible personal property of the defendant. Alternatively, you can take the judgment, file it in the Court of Common Pleas, and then it becomes a judgment in that and is amenable to all of the execution that a plaintiff might otherwise have in that court.
All right, how a case.
So, you know what, I'm going to interrupt you again. I apologize because it talks about no right to an attorney in a civil suit, but if in case there are people from Philadelphia watching this for some reason, there is actually some attorney for a day right for tenants in Philadelphia Municipal Court now. There have been some funds set aside for a group of organizations that have gotten together to help, you know, as an attorney for a day to represent a tenant. But I know Pittsburgh hasn't gotten to that yet, but I just want to make one note.
Thank you, Deborah. Although we do have neighborhood legal services,
Yeah.
a tenant can contact and they represent tenants in landlord-tenant disputes where the tenants are truly indigent.
Yeah. In Philly, we had so many people who weren't represented by community legal services or, you know, or turned that we actually, you know, got provisions for just an attorney for the day. So, yeah.
All right, on the next slide, the landlord and or tenant perceives there's a violation, so they can come in and look to try to file a case. The landlord or the tenant files a case in our office in the court where the property is located, and there are fees involved in filing that. I've never really had a tenant file a case per se. They file counterclaims and not necessarily a case. And there are times when they can fill out forms to waive that fee, depending on their financial situation. The next slide about advocates and interviewers to assist in completing forms. I believe, again, they have that in Philadelphia Municipal Court. Recently, due to COVID, there's been some advocates that have been in waiting rooms that more or less are there on hearing day. I know of no advocates that go to assist landlords to fill out forms whatsoever. And that the advocates, if there are any in Allegheny County, are their hearing day to talk to them. That they were there mainly to find out if they, with the CARES Act, and did they fill out any forms regarding it. And now they mainly advise, have they tried to get any of the assistance money? And if not, here's who you call and what you do, which we do anyway at the hearing. We'll get into that later.
Yeah, let's speed through this slide for a moment. So the landlord files a case. The MDJ's office sets the hearing for 7 to 15 days from the date of filing. So that's where when we say, look, fundamentally, a landlord plaintiff could file in the Court of Common Pleas. It's going to take you months to get a hearing. You file at the MDJ level. So that's an example of why you may want to, in a case where the landlord is owed $14,000, say, look, I'm going to waive $2,000, ask for $12,000, and keep it at the MDJ level. If an appeal is filed later in the process, you can still go back and get your 14. So then the court sets up the hearing date. The defendant does need to show up Otherwise, they may suffer, of course, an adverse judgment. There are no answers filed in MDJ, landlord-tenant actions, and the service of process is handled by the MDJ office. And in fact, under the state court rules, there's dual service. We mail one first class. In addition, a state constable will go out, knock on the door. If someone's home, he will hand it to them and file a return of service. Alternatively, if no one is home, they're probably going to tape it to the door and then file the return of service. We do grant continuances, but typically most courts, I think most judges aren't going to do it Thursday today for a hearing tomorrow, this afternoon for a hearing tomorrow morning at 9, absent a true emergency. If you're calling from the emergency room of the hospital and the hospital social worker faxes something, that's a different matter altogether.
This slide here and the next one you're going to see are both woefully inadequate by both the landlord and the tenant. Many times they come in not prepared at all with hardly anything, both the landlord and the tenant. Maybe a crumpled up yellow piece of papers where the landlord has what they think they owe, the tenant owes. But this is just common sense, but you'd be surprised how many people come in and don't even bring the court documents, the form that they actually fill out stating what they want. I'll say, did you bring this document? No, I didn't.
Yeah.
I'm like, well, you filled this paper. Is it correct or not correct? When I ask them how much they filed for, what's the monthly rent, things like that. So you can go down, as I'm saying, everyone here watching, this is all common sense that you think people would bring, but they don't.
And I can tell you, Judge King, I've had lawyers that when you say, well, do you have the lease with you? Well, no. And of course, pro se litigants will say, well, I have this stuff at home and I can get it here. Well, sadly, today is the day for the hearing. And this is true on both sides of the caption in these types of cases. So likewise, a tenant needs to bring, obviously, pictures, other things, receipts for rent if rent's missing.
Especially if they filed that counterclaim. You can't file a counterclaim just to ask for money because someone pulled them. But you need to document what your counterclaim really is about.
Talking just sort of a general overview, and I want to get to, I know we're going to be running short on time. Fundamentally, very important is the rules that we're operating under right now, which is President Judge Clark of the Court of Common Pleas of Allegheny County's Landlord-Tenant order, which regulates the procedure and the progress of these cases today. So I'm going to skip over who has power so we can spend a little bit of time talking about that. Fundamentally, this is worth noticing, though, and that is if an MDJ does render a judgment and the tenant disagrees with it, they can file an appeal at the Department of Court Records on the first floor of the City County building in Allegheny County. And with certain conditions, they can obtain a stay or supersedious of the change of possession so that it's going to be frozen in place until there's a further hearing at the Court of Common Pleas level. There is, however, the requirement that they have to pay rent during that tendency. And I can tell you, as a lawyer, I've advised landlords that are upset that they filed an appeal. And I say, what are you worried about? They have to pay, this is going to make them do something that you were unable to pay rent. Otherwise, the change of possession will occur. So I'm going to pass this a little bit and get to the COVID moratoriums. Of course, the federal CDC thing is no longer in place. However, the 5th Judicial District, Judge Clark, entered an order which essentially is designed to provide some more time for tenants to get emergency rent assistance through the ERAP program. And basically, what's in place allows a case for a non-monetary default to be litigated and go through to judgment, potentially possession, and so forth, yet sort of moving a little slower on the money defaults to allow the millions of dollars to catch up. And I can report that almost daily, certainly weekly, we have some cases where we get a letter from the landlord that says, please mark this case settled. We've been paid through ERAP funds. And so that case is off of the docket. The Administrative Office of Pennsylvania Courts every week lately has been issuing a report that gives us an idea of what they call the pending inventory of landlord-tenant cases in Allegheny County. Today's report reflects 1,141 pending cases. 398 of those are less than a month old. That's because there was a big influx of filing when the last stay ended. And then there was a few days before something else sort of fell into place. And then that CDC stay was removed. And then 543 of that 1141 are from 6 to 12 months. And then I didn't copy down the other older.
Two things that happened that really made this a change to a lot of landlords' thinking was the first program wasn't really run very well. The second program, Allegheny County, I got to give them credit. They took the lead and they got Department of Human Services involved, and they've been really organized in making sure that it's running. And then the third thing that helped a lot was the checks start rolling out and landlords talk like everybody, and they start finding out, hey, this is for real, and we're actually getting paid. So they got to educate themselves about it. I'm fortunate that I have someone from Human Services sitting there with a laptop. Every time I do a hearing, we can go in, find out, did the tenant apply? If they're applying, which stage are they in? Then I get them to look in and say, all right, what contact information did they put for the landlord? I make them read it back to the landlord. Is that a correct phone number? Or did they have an email? Is it correct? A couple of times, well, more than a couple of times, we found out, one number was reversed or whatever. So, with that assistance there, we're able to kind of timeline, because that 30 to 45 days, it's a little longer than that. But, we're able to make sure that any little glitch or mistake we can take out of it and get the checks running and to just get it rolling, because, some have been sitting since the old COVID days of, 7-8 months ago. But the checks are coming, so the landlords aren't as rough and gruff about the order. And Judge Clark's order was a kind of a middle ground, a common sense way to say, if someone applied for the money, we're going to treat it as a status hearing and explain some things to the landlord, because I tell landlords that are irate, this program's working. We move it through right now. You could do this. Do you really think you're going to get your money? And who are you going to rent to? If you do have a vacant place, maybe you will, maybe you won't. And now that they know and they buy into the program's for real and it's working, the process, not totally happy about it, but believe me, the process is working and it's helping people and it's helping landlords. And like I said, my area, I have I don't have any large, other than the 2 housing authority buildings. I have no real large entity. These are all people that are using this to gain income themselves. And they were hard hit with this too, especially people that had properties is what they were going to do when they retired from whatever they did. And these 8 or 10 properties were going to be their income. It hit them hard too. And I kind of, I understand the issue of worrying about the tenants, but everyone thinks landlords have a lot of money and they live in Bradford Woods. Well, they don't. They live right down the street from where they're renting the houses, and it hurt them too. And it's working well, is my main point. The program is working, and it's working as well as it could work, and I think they've done a great job.
To that, I would add that status conferences have been very effective. In fact, I had one today where we suggested to someone, look, there is an agency that's a walk-in center, because some tenants aren't particularly technologically savvy, or due to economic issues may not right now have a working phone where they can access their email account. And so there's a walk-in center where they can go, they will help you apply and so forth. The other thing I add to tenants is, look, when you get an email from the ERAP program, forward it to the landlord so that they know something is happening and what is happening, on the general thought that, look, when the landlord is a little more comfortable, you're going to be a little bit more comfortable because their goal in life isn't going to be on day 2 after some of these programs end to get back to court and evict you. So if the landlord collects for all this back rent, they may have a more charitable view of the future. I don't know if we have any questions yet for the in-person audience or the online audience.
Yeah, believe it or not, it's like 7 or 8 minutes.
For the online audience, I have actually been monitoring and answering some. I want to emphasize what you've said, that, communication between the landlord and tenant about the status of the ERAP is really crucial, because it definitely, but the landlord really appreciates that. So, but I don't know if there's anybody who has. There was a note here by Angarad Stock, who said that $35 million has been distributed so far in ERAP money. 5,600 households have been stabilized, and there is a lot more money available right now.
And Eric Stock is our court administrator here, and I will have to say,
Sorry, thanks.
she, besides knowing those numbers, the court went out and got these spent money, a lot of money, to have these big posters with all the where they could go in person and go where they were, their phone numbers, the map on how to get there. And we have them in our offices, and they're big, so I can see them. And then that helped. I have the Brashear Association in my area, and people are there all the time, and they've helped with that too. So that was very helpful.
So I don't know if there are any questions. Anybody have any questions that aren't in the chat?
Yes, here's a question.
Lori Hagan here from the Law Library. Are we able to also have posters like that to share with people?
Yes, I think we can make that happen, that the county law library will get posters and other information.
Call on Eric Stock.
And Department of Court Records if they don't already.
Yeah, I bet they do, but in the odd case that they don't, we'll follow up on that.
I believe that probably the housing court people have some of that type of information that they could probably even pass on down to court records downtown. I'm not sure though, but they may.
And I know among the materials is Allegheny County's local order that is in effect until the end of October. Another question from the in-person audience.
Yes, I believe I've heard that landlords can actually file an application for their tenants.
That's correct.
Can you explain why that would be, please?
Well, I'll answer it, although I don't know how good my answer is going to be. Some tenants are technologically challenged, whether in the same sense that sometimes I am, or perhaps because of economics, they don't have a working phone right now that enables them to upload documents.
Correct. That's the biggest issue. They have the smartphone, they communicate, but you have to upload the tax 1040 if you have it. You have to upload a lease. There's some other things that they sometimes ask for, and they can do some things on a phone, but they can't. That's why they got to get to a library down there, and that is good that the landlord can now get involved, which maybe should have been before. The T number. The thing to know on all this is the T number. If you have your T number,
because each application is assigned a unique number, which we refer to. It begins with a T, so we call it the T number, and that's used for tracking. But it's been very, very helpful to have representatives of the County Department of Human Services in the various courtrooms through the day and the week, so that when you have 15 landlord-tenant cases coming up, the DHS representative can say, oh yes, they're on step 3. We're not waiting for this. So it's important that you, Mr. or Madam Tenant, call this phone number and tell them how COVID has affected your income, because that's one of the steps.
One of the things too, in that quarter, Judge Clark did put in, there has to be a good faith effort by the tenant. When we continue these cases, I bring that up. You have a responsibility here. You have to be diligent. You have to monitor daily if they need some more information from you, because if you're going to be negligent and not follow this up, and I give you a 7-week continuance and you're still on the same step because you never did anything, well, maybe we're just going to move forward. So that they have to work too. And I really explained to them that the need to do that if they want to stay with everything.
And I know in the materials is some other resources, contacts for the Pennsylvanians for Modern Courts, and as well as the Philadelphia Bar Association and Neighborhood Legal Services here in Allegheny County, who does have lawyers that help indigent tenants with landlord-tenant litigation. But given the fact that we're conducting status conferences rather than trials now through at least the end of October, a tenant attends the proceeding. It's a conciliation or a status conference, and they're getting great information. And the program is working. The initial program run at the state level had a hard time really getting a lot of money to landlords and tenants. The current program operated at the county level, certainly in Allegheny County, I suppose in other counties as well, has been very effective in helping tenants whose income was affected because of the pandemic. And that in turn helps landlords. And as Judge King said, I can't tell you how many landlords I've talked to and said, look, if we give you judgment for $12,000 today and evict them, do you think you're going to collect this judgment? I don't think. And yet, if you bear with them for a while here through the ERAP program, you're going to get a check for, is it up to, I think, 15 months that they can cover.
And I can say that, obviously the pandemic changed a lot of things, and I've been a district judge for 28 years, and I can say that the involvement of the court itself in working and partnering with other groups and everyone has been something that I've in my career, I've never really seen go this far. We're not out there to be advocates. We're not there to take sides, but we're certainly out there to help people, both a landlord and a tenant, come to a resolution, not be homeless, and also not be out of money. And this money came as a blessing, and just to work through it all as best we can, and been a good partnership with the courts.
And so I'm going to tell you that's 100% true. There is twice a month a meeting of over 20 different organizations focused on this landlord-tenant issue, and the courts participate. Judge Clark participates, the administrator participates, Pittsburgh Foundation participates. I mean, this is a unified effort amongst many different organizations to make sure that people get help. So it is really remarkable.
Any other questions that we might be able to answer, whether in person or online, if you submit it through the chat, we're happy to take a stab at it.
Yeah, I think we are good. I haven't seen any other questions that we haven't answered.
Okay.
So I want to personally say thank you both so very much. I mean, I've been taking lots of notes, and I will edit my slides. And the slides will be available through the Pennsylvanians for Modern Courts as well as the Allegheny County Law Library. But I'm gonna edit them to add some of your comments tonight. And I truly thank you for your time and the Allegheny County Law Library for putting this on. This was terrific.
Thank you, Deborah. And I know Lori Hagan from the County Law Library has something that she needs to add to wrap up everything for credit. So thank you.
So much. Thank you, Debbie. This is a wonderful opportunity, and we are looking forward to doing more of these in the future with you. So just for a little bit of housekeeping, anybody make sure if you're getting CLE credit, I have a list of names that are on the PACLE list that I have gotten, and just make sure that I have your Pennsylvania attorney ID so that I can make sure that that credit gets in for you. Again, that takes about a month for that to process. Actually, they're even a little bit behind as well, for obvious reasons. I also want to thank Pennsylvanians for Modern Courts. I also want to thank both judges, Barton and King, as well as, for the PowerPoint. This has just been wonderful. Please stay tuned for any future programs that we may have through PMC Online, as well as ACLL IB at .org. And that's our website. If you look under events, we have events as well as CLE things. We combine them. We actually color code them. So if it's for the general public instead of a CLE, we have them coded as such. But anytime you have a question, you could certainly contact me Again, my email, just to help you, is Hagenl, Hagenl, @duq.edu. Also, Tom has offered his email. If you had any questions concerning with PMC, you can email him at tbailey, that's BAILEY, @pmconline.org. Please give us feedback. We want to know how well we did. What could we do better next time? Is there a topic that nobody has covered that is really burning that you want us to cover? Please let us know, because we will do everything possible to make that happen for you. Thank you so much for your time and listening and attention. Thank you so much, and good night.
You can contact us by visiting the Allegheny County Law Library in the City County Building at 414 Grant Street, room 921 in downtown Pittsburgh, Pennsylvania, zip code 15219. Or you can phone us at 412-350-5353 or email us at acll@duq.edu or visit our website www.acllib.org. We are open to the public 10 a.m. through 5 p.m. Monday through Friday, except on court holidays. We strongly recommend making an appointment in advance of your visit to receive individual assistance from a librarian. We hope you have found this presentation helpful.